All right, good morning. Good morning. We will get started with our next presentation. Good morning. My name is Jeremy Early. I've been up here a few times. I'm going to try to keep us organized and on time today. For the remainder of the day, I was willing to do this because I don't have to take questions from you all, so I just have to read from a script, so we're good to go. A couple announcements before we get started. As you're getting seated, if you have an open seat next to you, can you raise your hand to help the monitors? Oh, quite a few spaces, so all right, excellent. Thank you for doing that. Second announcement. Yesterday, we had a colleague lose a bracelet, possibly out in the atrium. So if anyone has seen that bracelet, if they could return it to the registration table, that would be excellent. And now I'd like to introduce my colleagues here at the table. So Tamy Abernathy, she is the Director of Policy Coordination Group, and Dave Musser, the Deputy Director for Policy Implementation and Oversight. They are back on the stage with us to give the federal update. So please give them a round of applause.
I still am technically.
Good morning. I wore black because if you throw tomatoes at me, it won't show. But I want to start off with some really, really great news. Wednesday, as you well imagine, was very difficult. We had a lot of questions that we just simply could not answer, and you had a lot of needs. And what I have recognized is that you, with boots on the ground, need to be able to communicate with us to help you do what you need to do very, very soon. Yay! I'm off to such a good start here. We will be hosting, starting as early as April, Friday webinars where we will sit down with you and answer your questions, if we can. We always reserve the right to say we just can't answer that yet, but if we can answer it, we will. And as we navigate through the negotiated rulemaking process and we are getting ready to publish a final rule, there'll be more and more things that will have been solidified where we can present that to you. So if you will bear with us, as early as April, the first week, we're going to start trying to have what we call listening sessions and engagement with the department so that we can give you what you need. We heard you, and this is what we've been able to do in just 2 days. All right. Good morning. Again. Oh, that was good. That was kind of good. We do appreciate that you are joining us for the federal update. And I'm pretty sure by now you all know who I am, whether you want to or not. And I am the director of the loans team in the Office of Postsecondary Education. It's called the Policy Coordination Group. I have two of my wonderful staff here with me, Renee and Chelsea, right here in the front row. When the session is over and we have a break, if you can't reach me, you can get to them. They'll take your questions, and we'll get back to you as soon as we can. I also have the privilege of co-presenting with this guy over here, which we did at NASFA, and that was kind of fun. And it's always a great joy to present with other people that can take heat when you're standing up here. Yeah. And after yesterday, I heard he was like a rock star, so I feel like I'm in really good company. All right. I have this thing right here that I think we're able to start the presentation. Dave and I, our contact information, I'm going to leave that up. Like I said, if you need to reach me, please email me or give me a phone call. Except for the not next week, but the 2 weeks after that, well, I will not be in the office. I apologize. But I will get it when I get back. All right. The 2025 One Big Beautiful Bill, or Working Families Tax Cut Act, they're kind of simultaneously connected at this point. We don't know if we're calling it the One Big Beautiful Bill or OBBBA or the Working Families Tax Cut Act. So both of those made numerous amendments to the Higher Education Act of 1965 as amended, and several provisions were effective upon enactment. The provisions in this bill have effective dates of July 1, 2026, July 1, 2027, July 1, 2028. We have prepared the presentation in advance of the final rules for both the Reimagining and Improving Student Education, or RISE regulations, with changes to the federal loan programs, and for the Accountability in Higher Education Access through Demand-Driven Workforce Pell Ahead regulations. The information contained in this presentation is subject to change depending upon the outcome of the department's rulemaking process and the comments that we receive from the public. So therefore, it is preliminary and has not any predetermined outcomes or policy decisions that may be made and published in the final rule. Oh, I guess I'm going the wrong way. Let's try to go the right way. Our agenda. We have a very full and important agenda to cover. So we'll begin today with an overview of the rulemaking process, what governs it, why it matters, and how it shapes everything that follows. We'll discuss the latest public service loan forgiveness updates, or PSLF, including the rulemaking timeline, definitions, and employer eligibility standards. We'll then turn to the changes resulting from the One Big Beautiful Bill Act for the RISE provisions, and then I'll finish my part with additional loan guidance. I'll turn the presentation over to Dave, and he will cover FAFSA updates, the ahead provisions, including workforce Pell and accountability, and recent non-loan policy updates. If there is time at the end, we might take a couple of questions. Oh, I thought you guys would be happy about that. All right, let me just keep going. The rulemaking process. As you are aware, the department started negotiating on the Public Service Loan Forgiveness Program in 2025. We have recently concluded negotiations on the One Big Beautiful Bill, and so before we dive into discussing all of those program changes, we wanted to start with the rulemaking process. Section 492 of the Higher Education Act requires the department to use negotiated rulemaking, or NEG-REG, to develop proposed regulations for the Title IV programs. How many of you in the audience have participated in one of our NEG-REG activities? For those of you, thank you for your service. For those that have not, we are always looking to connect with our partners and our constituents so that we can make sure that our rules are effective across the institution. So please consider your involvement in the future. The department convenes a committee of stakeholders, those from the community that have vested interests in the topics being negotiated. So for loans, we of course want borrowers for loans, we want student veterans, we want institutions, servicers, lenders. Dave's table, usually accrediting agencies and those constituents that actually are more in line with the Pell and the institutional side, not the non-loan side. So we pick the constituents that are best served by what topics are at negotiations so that we can get a full-rounded rule out to you guys. We review the proposed regulations, negotiate in good faith with the ultimate goal of reaching consensus. The Administrative Procedures Act provides major steps of the rulemaking process. So we publish a Notice of Proposed Rulemaking, or NPRM. We hold public comment for at least 30 days and publish a final rule that addresses substantive comments. The Negotiated Rulemaking Act, or NRA, structures the department's responsibilities during committee negotiations by providing a procedural framework. So you see the department's Title IV rulemaking process is guided by statutory provisions in the Higher Education Act, the Negotiated Rulemaking Act, and the Administrative Procedures Act. So said another way, 3 acts are better than 1. Negotiated Rulemaking Timeline. This slide shows the regulatory timeline for a rule that follows the normal process articulated by the master calendar. We reach out to the department first for input and engagement by issuing a notice of intent to negotiate that announces the dates of the public hearing for our public or hearings, and announces the negotiations and solicits nominations for non-federal negotiators. The public is usually provided 30 days to comment on that. The department then holds committee sessions. We issue draft proposed regulations, if we're lucky, by the first session, and then we take consensus checks throughout the negotiation process. At the end, we take a final consensus check. We draft the NPRM, and then we start the public 30-day comment period. So once comments are received, they're reviewed, and the department responds to commenters in the final rule, which publishes in the Federal Register, typically 30 days before the effective rule, but there are some times it publishes a different timeline. Regulations that are finalized and published by November 1st of a year generally become effective July 1 of the following year. So a key milestone for negotiated rulemaking is to publish on or before the November 1st deadline so that the rule may be effective July 1, 2026, if it was this year. The Secretary may choose to exercise discretion for early implementation, and if so, this would be clearly articulated in the supplementary information section in a final rule. So for those of you that are familiar with our rulemaking process and you're looking for those effective dates, the implementation dates, that's where you're going to find those. That gets particularly important for the RISE package because of the 4 implementation dates. So we had, Ashley mentioned consensus the other day. I have slightly different definition of consensus being a federal negotiator from this perspective. It is unanimous agreement or no dissent. So silence or absence counts as agreement. So if the committee reaches consensus, and as Ashley said, y'all can live with it and you're going to say okay, then ED publishes proposed regulations consistent with that consensus language. If not, ED maintains flexibility to revise the proposed rules. I think this quote by Chris Voss sums it up nicely. Negotiation is the heart of collaboration. It is what makes conflict potentially meaningful and productive for all parties. As you can see, the department's negotiated rulemaking process is built on collaboration with you, the community. The next section introduces the updates to the Public Service Loan Forgiveness Program. The slides will cover the regulatory timeline, definitions, employer eligibility standards, and corrections. On March 7, 2025, President Trump signed the executive order on restoring public service loan forgiveness, which directed the department to redefine qualifying public service to exclude organizations with a substantially illegal purpose. The department published the intent to negotiate on April 4th, and the Student Loans and Affordability Committee was created. The department held 2 hearings, one in person on April 29th, and the virtual hearing was on May 1st, 2025. We held negotiations from June 30th, 2025 through July 2nd, 2025, and there was 1 dissenting vote, so this committee did not reach consensus on the proposed rule. The department published the Notice of Proposed Rulemaking on August 18th, 2025, and we received 13,989 comments, and the final rule was published on October 21st, 2025. I wish we were at 13,000 comments on RISE, but we'll get to that in a minute. The regulations have an effective date of July 1, 2026, and you'll recall from our conversation on timelines earlier in the presentation, this rulemaking timeline followed the master calendar. You published the final rule by November 1st for an effective date of July 1, for the next July 1, 2026 in this case. We published by November 1st, and it's effective July 1, 2026. PSLF added and revised definitions. So under the PSLF program, we established new definitions and redefined qualifying employer. 12 new terms were defined to establish what constitutes a substantial illegal purpose. These definitions are added to the existing definitions in our regulations found under 685.219. B, you'll find all of the definitions. And some of these definitions we established are, aiding and abetting, trafficking, illegal discrimination, substantial illegal purpose, and there are many others. These definitions will assist the department to consistently determine employer eligibility. The department also redefined qualifying employer to exclude any employer whose activities have a substantial illegal purpose, and we've added to the existing definition that a qualifying employer does not include organizations that engage in activities such that they have an illegal purpose as defined in this section. There's a link on this slide. If you wish to have additional information, please click there or reach out to me or one of my team. There is a standard and a process for the employer for us to determine whether an employer has engaged in activities with a substantial illegal purpose. So we built in a process for employers to work with us, contact us, be in conversation with us. We're not just saying, okay, boom, you're done. We have built this process for engagement with the employers. We feel like that is fair and that is equitable and making sure that we make right decisions before removing a qualifying employer. One of the standards, or the standard, is considering a preponderance of the evidence. Preponderance of the evidence is one type of evidentiary standard used in burden of proof analyses and considers all information available. In this case, the department may determine employer ineligibility based on a final judgment, a guilty or no contest plea, a settlement with an admission, or a failure to certify that the employer is not participating in a substantial illegal purpose, as certified on the Public Service Loan Forgiveness and Temporary Expanded Certification and Application Form. The department will notify borrowers and employers of findings and will provide an opportunity for the employer to respond to the substantial illegal purpose finding prior to issuing a final determination. Remember, preponderance of all evidence will be considered. Borrowers will be notified of this pending action, and if it is determined that an employer has participated in a substantial illegal purpose, the employer is disqualified as a qualifying employer for the purposes of PSLF for a period of 10 years. Employers may regain eligibility after certifying corrective actions and working with the department. Borrowers retain credit for PSLF payments made while the employer was eligible and while a determination is pending. In no instance do we want to harm borrowers in this case. So while all of this activity is going on, until a final determination is made and the Secretary has made a decision, borrowers continue to receive credit towards the months toward forgiveness. The department is working through operational details about how this process will work on our side, but it is effective July 1. On October 31st, 2025, the final rule was published, and we included some technical instructions in the regulations for our regs that weren't quite what they needed to be. So I just want to let you know that there will be a correction coming out. It's minor, and you don't have to worry about it. It doesn't change anything substantively, but it does change just some of the paragraph instructions in the regulations so that when the July 1 regulations are published, they are accurate. We are also going to issue that correction 30 days prior to the effective date. So it will be no later than June 1st, 2026. All right. There's the correction to the final rule. Let's shift our attention to the one big beautiful bill, Reimagining and Improving Student Education, Changes to the Federal Student Loan Program. Boy, there's a lot to unpack here, isn't there? So as I move through this presentation, we're going to get to, I know, the things that are most pressing to you. Schedule of reductions, loan limits for interim exception. We heard you. We have some answers. So I am glad that we get to have another time for me to be in front of you and give you some of the answers that we have already, and provide you a way forward so that we can get you more answers, because you are the ones that have to process this, and it's hard because it starts right away. And we need to be able to be present and with you and help you navigate through summer headers, summer trailers, all of the fun things that go with crossover periods and all that fun stuff. So President Trump signed the Public Law 119-21, the One Big Beautiful Bill, into law on July 4th, 2025. The bill made statutory changes to the Higher Education Act of 1965 as amended, and therefore the department was required to hold negotiated rulemaking to promulgate rules. Because in our process, when there's a change in statute, there's a change in regulations, we have to negotiate those. And sometimes we're held to that standard, to those words in the statute, and sometimes we don't have as much flexibility, but we still have to meet to try to make sure we get the rules right. 24 days later, the department published its notice of intent to negotiate in 2025, and we announced both the RISE and the AHEAD committees. The department held one virtual hearing on August 7th, and the first RISE negotiations were held on September 29th through October 2nd. The second were held November 3rd through the 7th. The committee did reach consensus, and we published a notice of proposed rulemaking on January 30th, 2026. The comment period just ended at 11:59 p.m. on Monday. It is burned in my brain. The Secretary amends 17 regulations for the federal student loan programs as authorized under the Higher Education Act. And we are implementing those statutory changes that Congress made, and we're doing that through the OBBB. We revised direct loan program regulations in 685, Part 685 of the regulations, amending the annual and aggregate loan limits for graduate, professional, and parent loan borrowers. The regulations implement 2 new streamlined student loan repayment plans for new borrowers, which I understand. You guys heard all about the loan limits on Wednesday and the repayment plans on Thursday. So I get to skip all this, right? Oh, come on, I thought you were going to say yes. So the repayment assistance plan and the tiered standard repayment plan, those are the 2 new streamlined loan repayment plans. The regulations also making conforming amendments to current regulations on consolidation, deferment, forbearance, public service loan forgiveness, additional and separate apart from what we already did in the public service loan forgiveness negotiated rulemaking. The regulations also provide borrowers in default a second opportunity to rehabilitate their loans and resume repayment, even if they have previously rehabilitated their defaulted loan. There are 4 implementation dates for the regulatory provisions impacted by the One Big Beautiful Bill. Unless otherwise noted, the regulations are effective on July 1, 2026. However, effective July 4th, 2025, provisions related to partial financial hardship for income-based repayment is, I'm not going to read the sections for you because you probably don't really care what sections they're in. It's just that that condition to enter an income-based repayment plan has been removed. July 1, 2027, provisions related to loan rehabilitation in those respective sections, which include Perkins and the direct loan and the Family Federal Education Loan Act. So all of the loan provisions are impacted by this rule. They'll relate to deferments, and then we have the same thing for forbearances. And then, of course, we added a minimum payments and reasonable affordable payments for defaulted loans in the same regulatory provisions as well. So right now, we're sitting at over 76,000 comments that were received in our NPRM. So we are still validating, and we expect that number to fluctuate. So one thing that the department does is when we have mass letter writing campaigns, a comment that comes in from thousands or tens of thousands of individuals, we post one sample of that comment, and we list the number of commenters that one sample represents. So if you sent something in as part of a letter writing campaign and it was exactly the same letter as all the other ones, that would be counted one time. You'll see that one representative sample posted with the number that represents everyone that made that same comment. We also take co-signers of a comment or a letter, and we add those. So the numbers have to fluctuate because we have to validate, did this letter have 20 signatures? Did it have 25? Did it have the 5,000 that they said it had? And we've gotten a lot of those. A lot of times when you're putting things in an FDMS, regulations.gov, you're putting in those fields, completing those fields. And so if you say, yes, your comment has 10 attachments, or yes, it has 5 million signatories, we have to validate that because we're putting this information out in the public. And so we want to be very transparent with you how many people have commented on this rule, and so it takes us a little bit of time to get them all posted. So I've had a couple people ask me, I commented, how come my comment's not out there? I think we're down to the last 300 that are being reviewed for just the preliminary review, and then they'll go back into the quality checking. And then it filters to my team, and we process it so that we look at the substantive comments and respond to those in the final rule. So we will articulate all of the dates that I've talked about and the substantive comments in the final rule. And the master calendar for PSLF was it followed, you publish by November 1st, it's effective the next July. For RISE, that's not the case. The rulemaking was not announced until July 25, and the intentional effective date of July 1, 2026 does not really give us a possibility to undertake every step of the negotiated rulemaking process by November 1st to have a final rule published by November 1st that could be effective. So what happened is Congress was well aware of the impossibility when they passed the OBB. Congress made us do this, right? And they made us do it by this timing. And so we have to make sure that we do exactly what Congress has asked us to do to the best of our abilities. And so these provisions that go into effect on July 1, 2026, that are not self-implementing and can't go into effect until we promulgate a rule, that's where we are now. Those are some of the provisions that you're hearing about and that are causing you the most angst, and we get that. We do hear you. So for provisions that become effective July 1, 2027 and July 1, 2028, Congress did not implicitly repeal the master calendar because it is possible for the department to follow the master calendar implementation schedule. So these dates fall under the master calendar, whereas the 126 does not. I briefly mentioned that there are numerous provisions that were effective upon enactment, and these include partial financial hardship, as I mentioned, for enrolling in an income-based repayment plan, and allowing borrowers with consolidation loans that are repaying Parent Plus loans to enter income-based repayment, and counting repayment assistance plan payments toward PSLF when the repayment assistance plan becomes available. We will also publish notices that delay current regulations to July 1, 2035 for borrower defense to repayment and closed school discharge, which was effective upon enactment. The bill has restored the borrower defense to repayment regulations that were in effect on July 1, 2020, and the closed school discharge regulations that were in effect before the November 2022 regulations, and that is the July 1, 2020 regulations are restored. Even though we have not drafted those notices and pushed those out to you yet, those dates were effective, and so we are already operating under those current rules, and we have pushed the other rule out to 2035. So this slide talks about the professional student definition. And when I tell you we have heard from the community on this, I'm sure you can well imagine, because some of you in this room have contacted us about this. I want to separate a distinct difference here. We apply the definition of a professional degree in our regulations under 668.2, which are general provisions for the Title IV programs. And what was in effect on July 4th, so we proposed to define the professional student in the loan provisions under 685.102 to mean a student who is enrolled in a program of study that awards a professional degree upon completion of the program. So the distinction here is for the loan programs only, we're defining what this professional student means. And what we are using is largely from the statute and one extra. So a professional degree that signifies both completion of the academic requirements for beginning practice in a given profession and a level of professional skill beyond that normally required for a bachelor's degree is generally at the doctoral level and requires at least 6 academic years of post-secondary education coursework for completion, including at least 2 years of post-baccalaureate level coursework. It generally requires professional licensure to begin practice and includes a 4-digit program zip code as assigned by the institution or determined by the secretary in the same intermediate group as the fields listed in our statute and then will be listed in our regs: pharmacy, dentistry, veterinary medicine, chiropractic, law, medicine, optometry, osteopathic, medicine, podiatry, theology, and clinical psychology. Clinical psychology was added. That was not in the statute. It will be in our regs. As you can imagine, we received a number of comments related to the professional student definition and degree fields. I want to articulate here and really tell you the professional student as used in the NPRM and the proposed regulations is intended solely to distinguish those programs that we propose would be eligible for higher loan limits. And that was required by the OBBBA. The designation or lack thereof of a program as professional does not reflect a value judgment by the department regarding whether a borrower graduating from the program is considered a professional or whether those that have already graduated in the past and are in those professions. That has nothing to do with profession. We are talking strictly about the professional degree, the professional students, and the loan limits only. So when those who are currently and have been in those fields that are not enumerated in the statute, we have heard from them too. And we interpret the phrase professional student only for loan limits. I'm going to say that again, only for loan limits, because I think there's a grave misconception out there that the department does not believe a profession is professional. And that is not what the department intended to do. The department intends to follow the letter of the statute to clearly distinguish and define what a professional student is and a professional degree so that it applies to the loan limits. I could sit here and read all of these wonderful things that we did in the 17 reg provisions that my team is drafting or redrafting, and I don't want them to throw tomatoes at me, so we won't go through every single one of them. But if you need to know what they are here and they can tell you. Honestly, most of what you've heard, loan limits and repayment plans and all that fun stuff, that's already there. So let me get to my next page. All right, so this slide, we've talked mostly about this. And I'm not going to go through in-depth loan limits because Ashley did a fantastic job on that and all of the other pieces and parts for the loan program. She kind of covered that on Wednesday. And so we'll be here for questions, but we will talk a little bit about, the sunsetting of the program 2028, sunsetting of pay and ICR, classic ICR plans. Those end in 2028, so that particular piece of information will not be effective until July 1, 2028. All right, like I said, aggregate caps, right? The graduate students, effective July 1, 2026, they can borrow up to $20,500 annually and $100,000 aggregate. And professional students can borrow up to $50,000 annually and $200,000 aggregate. Beginning on or after July 1, the aggregate limit for graduate student who is or has been a professional student at an institution is $200,000, less any amounts such student borrowed as a professional student. Because the bill amended Section 455 of the Higher Education Act, it phases out graduate and professional students' eligibility for direct loan programs for any period of instruction beginning on or after July 1, 2026. So the Higher Education Act lists the conditions for the interim exception for a graduate student or professional student to obtain a direct plus loan on or after July 1, 2026. But a borrower who withdraws or otherwise ceases to be enrolled would lose that continued eligibility under this interim exception. And if a graduate student received a direct unsubsidized loan for enrollment in a graduate program before July 1, 2026, they would be eligible for the interim exception for continued enrollment in that same program after July 1, 2026. We know that there are borrowers who meet the limited exception and will be able to continue to borrow up to the cost of education, less any other financial assistance. So before we get all upset, we heard you the other day when Ashley said if a borrower is in a 2-year program and they come back for that 3rd year in 26-27, they're not eligible for the interim exception. We are taking this piece back because we believe we want to clearly get the regulations correct and make sure we do not believe the intent of Congress was to harm little Johnnies and Susies in their last year. We thought we probably had the reg text right, but we are going to take a deep dive and look at that. We are going to work with our Office of Management and Budget. We're going to work with other policy directors, our Office of the Undersecretary, and when we come back, we are going to get you the right information, and it will be soon. It will be soon. Please don't change any of your programming yet. Let us get you that answer. You have a personal commitment from me. Those of you who do not know me in this room do not know that when I say I'm going to do something, I do everything my level best to do that. And 9 times out of 10, if I can't do it, I'll die trying. Those of you in the room who know me, am I right or wrong? They know. I will work to get you the answers that you need, to get your students ready for the fall term, the summer term, everything that you need. We are already taking steps to meet you where you are, to help you process a very complicated change to all of the loan programs. All right. So, if a student is enrolled in an eligible program, except for a non-term program at an institution on less than a full-time basis during an academic year, the amount of any direct loan the student may borrow for an academic year or its equivalent would be reduced. And this is in direct proportion to the degree to which that student is not enrolled on a full-time basis as of the date the institution determined the student's eligibility for the disbursement rounded to the nearest whole percentage point. The formula to determine the reduced annual loan limit percentage is equal to the number of credit hours enrolled for an academic year, or the equivalent, divided by the number of credit hours considered full-time by your institution for that academic year for the program of study, and then multiplied by 100. We call this the schedule of reductions. It is built on enrollment status. I remember the other day, this was not a favorite topic of yours. And as of Wednesday, it wasn't a favorite topic of mine. Before Wednesday, it was great, but Wednesday kind of made me a little gun shy. I was a little afraid to come up here, so I wore black. What I can tell you is we built this schedule of reductions with flexibility for you as the institution to do what you need to do. So if you are a summer trailer on the 25-26 award year, this is not effective until July 1, 2026 for the 26-27 award year. Now, I was told by Brad Barnett that you guys would be really happy about this. So if your summer is a header and it begins July 1, 2026, then the schedule of reductions applies. So you have to look at that at your campus. The best part about this is we said you're not required. So it's an annual loan limit, right? You're not required to send money back, nor are you required not adjust the fall if you so choose. If your packaging and your philosophy on your campus wants to reduce the fall term or the summer term by the enrollment, you are permitted to do so. This is an annual loan limit. So if you are a summer header, summer, fall, spring, you're going to look at that summer term, what's considered full-time for that summer term. You're going to figure out the calculation, and you're going to award that borrower that money. In the fall, they say they're going to take 9 hours and they only take 6. You are going to look at this, and right now they are already not taking full-time, so you have to look at what you want to do. Do you want to wait to the spring and adjust it? Sure, you can do that. If that's not something your campus wants to do, you don't have to. You can adjust it. This is an annual loan limit. The borrower is entitled to that annual loan limit, and you have the flexibility to decide what is best on your campus as you navigate through the schedule of reductions. We're going to get to this, hopefully. So, this was effective upon enactment, which meant it would have started for the 25-26 academic year. We could not, as required by the statute, publish the schedule of reductions and get that out to you, given that we just got the bill July 4th signed, and we had to negotiate. We could not negotiate until we did all of the steps to get the negotiations out there. We informed the community in a Dear Colleague letter that this would be effective for the 26-27 award year. Okay? So I want to reiterate, flexibility, you get to do this. And for those of you who know Brad Barnett, he is not shy. He came right up to me and said, hey, we need to get this straight. This is what we need to hear from you. So I am clarifying. If you have 3 terms instead of 1, you have flexibility. If 26-27 is subject to the schedule of reductions, the denominator for determining an annual award year full-time definition is determined by you, right? You determine that. Now comes the fun stuff. We were asked by Emily. Emily, are you still in the room? I don't know if Emily is still with us, but Emily sent me an email, and she said, hey, we need help. Let's figure this out. So we created this chart. The first thing you should do when you look at a schedule of reductions is not try to prorate the cost of education yet. the first thing you look at is what is the loan limit maximum this borrower can receive as a full-time student? How are you calculating it? Is it a summer, fall, spring, summer? You don't award for summer. What do you do on your campus? What do you determine as full-time? And what is your practice going to be as you navigate through those three terms? I will admit, during negotiations, we only had standard academic years questions and examples. I am sorry we were not thinking about the borrower-based schools or other subscription-based programs, other programs in there. I would love to meet with the borrower-based schools to get some examples on how best we get examples on and out there for you as soon as possible. I've talked to Jared this morning from Capella, and the gentleman that, if he's still here, that had the question because I could not answer it, that stood up and talked about borrower-based wanting examples. If you would see me so I can get your contact information so we can get some information from you and get it out as soon as possible. We are committed to expanding our examples to include the programs that we need to have examples for so that you know what you're doing on your campus. Again, with our listening sessions and our interactive sessions together starting in April, or no later than April, we're going to be able to talk through a lot of these additional questions that you have related to loan repayment, loan limits, and schedule of reductions. This is a big lift, right? I think when I said let's not make it complicated, I was thinking of basic 1, 2, 3 math. I heard from you, it really is complicated, and it's more complicated because we didn't give you everything that you needed to be able to do that. So you have my word and my team's word that we are striving very hard to get you what you need, and this is a first step. So you have the full-time eligibility, right? Here's the cost. Column 1, unsub 20,500, grad plus 59.5. Step 2. What's the loan eligibility for fall? They're full-time. They would get half, right? In this case, it's half. And I'm sorry I don't have an example for borrower base, but I want to make sure I get that right, so I want to work with you first before I put an example out there. So in this case, cost of education, we would split it, right? 40,000. Unsub, 10,250, and grad plus, 29,750. Then you would go to step 3. What is the standard of reduction that would apply to a less than full-time student? What's the loan limit? So you get the calculation, and you get 78%. That 78%, you get the new amount. Okay, they get to keep $15,990 for unsub and $46,410 for unsub. But in the fall, they already received half, right? They received half of the unsub amount and half of the plus loan amount, which is why we waived 685,303 substantially equal disbursements. Because in the spring, now you have to look at, okay, here is the loan limit. Here's what they're eligible to receive. The cap that they're eligible to receive is the $15,990 and the $46,410, of which they've already received $10,250 and $29,750. So you have to take what they're eligible now under the schedule of reductions, less what they've received already, and that becomes their new amount for that term, providing they're full-time. If they're more or less than full-time than they were before, then you have to figure the calculation accordingly. So in this case, they were 9 hours. Her calculation was in 18 hours, and they ended up not being full-time at 18.9 in either grad school. And so we had to figure it for that. So this is exactly a fixed scenario, but you get the idea. It's the same concept when you go back to your campuses and you're looking at what is that schedule of reduction. You look at the maximum loan limit first. Then you look at the cost of education. All other eligibility criteria applies, for instance, SAP, all of those other things, enrollment, if you're less than half-time, of course, you can't get a loan. But in this case, when you're looking at applying a reduction to an annual loan limit, you have to take it from the loan limit first. Determine what the maximum loan limit could be as a student and in their enrollment. And then that's your benchmark. What did they get? What can they get? And you have those two sides of the coin. And when we do the borrower-based academic year, it's going to be the same thing. If the borrower-based academic year ends in the 25-26 award year, then they're not subject to the schedule of reductions. But if it starts or it has the 26-27 award year in it, then it's going to start with a schedule of reductions. So 25-26, it's not, you don't do a schedule of reductions. You're not required to do that. But for 26-27, you are, and forward. Does that make any more sense? Brad, you told me they were going to be really happy if I said this. So, I know it's still confusing, and you're seeing it on paper, and you're not seeing it in words, which is why we want to make sure that we're meeting with you should you still have questions. We want to make sure that we give you the information you need to process this, especially when you're starting in the summer, which starts like soon. We know you need help with that, and we are here to do that. We want to make sure that you clearly understand the regulations, the requirement made by the statute, made by the bill, and made by our regulations. All right. I really did expect y'all to be so happy. Kind of sad. So remember, the denominator, it's going to be your cost of education. So, beginning July 1, 2026, an institution may limit the total amount of direct loans that a student or a parent on behalf of such student may borrow for a specific program of study for an academic year, as long as any such limit is applied consistently to all students enrolled in that program of study, and an institution chooses to limit that borrowing under this provision, is required to document their decision and follow standard requirements for record retention. I got a wonderful question, and the school said, what if we know the program is 14 credit hour, 14 different quarters? Thank you. You heard me. There you go. And that limit is not going to be enough. Can we go ahead now and change the limit for each of those respective quarters so that the borrower can have money through the whole length of the program? You may. As long as it applies to every student in that program, you clearly and conspicuously have to get that information out right away. What we don't want to have happen is borrowers think that they're not eligible to have the funds to complete their program of study. So yes, you as an institution, you have been asking for being able to limit loans for years. I have been doing this for 39 years, and I remember years and years and years ago, my school, we would have loved to have been able to limit certain things and certain programs because it just was the right thing to do for the borrowers. But we were not permitted to do that. So I hope this helps you understand that this could be a real benefit for those students that would not have enough eligibility if they got the maximum right away. They wouldn't have enough to finish their education. So you as a financial aid professional are already looking proactively at that and adjusting so that this student can matriculate with the funds they need and finish their education. All right. For the purposes of those institutionally determined loan limits, so a program of study means eligible program. So let's just make sure that we're in an eligible program, and then you set those program-specific caps for that program of study, just like we talked about. Huh? I sure did, didn't I? I can't see with my glasses on far, but I can't read without them, so. Okay. Loan repayment milestones. You guys heard a lot about this yesterday. I understand Eric and company did an amazing job talking through the repayment plans. But let's just take a minute. So ICR, pay, repay, and the alternate loan, effective July 1, 26, no new loans. Borrowers can continue repaying. For the fixed repayment plans, including graduated and extended, no new loans may be dispersed. Borrowers may continue repaying. IBR, removal of partial financial hardship. The plan remains, but no new borrowers may enroll on or after July 1, 2026, but they can enroll in repayment assistance plan. Once the program is established, they may disperse new loans. And then there's the tiered standard, which is the program established, and they may disperse new loans, and new Parent Plus loans are only eligible under the standard. So say that plan right now, we are still in fluctuation. I'm sorry I don't have any updated information that I can share with you, but as soon as we get that information, we will be sure to give you, share that with you. So effective for July 1, 2028, we know that the ICR plans will be sunset. So we are hoping that all of the students, the Johnnies and Susies and the moms and the dads that are under those plans will get out of those plans, no later than June 30th or even sooner, so that we can process and make sure that everything is status quo for them. Borrowers must enroll in either the IBR, RAP, I'm not supposed to say RAP, Repayment Assistance Plan, or Tiered Standard, or you will be auto-enrolled. So make a choice, because we want to give borrowers a choice. They can also continue paying under the existing fixed repayment plans, graduated and extended, and as long as they don't get a new loan, they can stay in those plans, but the minute they get a new loan, they have to transition to one of the new plans. Because remember, we streamlined down to 2 plans, Tiered Standard and Repayment Assistance Plan. So IBR, they can continue to pay. Borrowers from other programs for the Repayment Assistance Plan, they've got to complete the transition by July 1, 2028. And then borrowers from, in the Tiered Standard, borrowers from other programs can complete the transition as well, and then borrowers transition to IBR, Repayment Assistance Plan, or Tiered Standard if they're in the SAVE plan at some point, and we'll get more information for you. The legacy plans stop accepting applications for new borrowers in 2026, and they sunset in 2028, so we need just to make sure that we have that down pat. The rest of the presentation is a little bit about loan guidance, and then I'm going to turn it over to Mr. Musser, thank goodness, because I'm tired of talking. And I'm sure you're tired of hearing me. Additional loan guidance. So my team deals with Perkins and, like I said, Federal Family Education Loan Program, and we deal with all of the loan aspects, so total and permanent disability. We did have some information. I don't believe that first link is working. I'm not sure what happened to it, but for somewhere along the way, we kind of got it skewed, so I apologize. Just ignore that first link. But this information is not new, but we did move the total and permanent disability processing, and we transitioned it to student aid in March of 2020, studentaid.gov, March of 2025, and loan assignments resumed in July of 2025 under the new servicer. So I just wanted to make sure that you were aware of that in case it comes up and you don't know where's the servicer. That servicer is now all transitioned to the Department of Education. They were always serviced by the Department of Ed, but truly just one of our servicers and not just a single servicer. So the process transitioned, and now borrowers are back on track and submitting their forms. So if you hear something about that and something's askew, please let us know so that we can go ahead and reach out to that borrower. All right, Perkins. Everyone who knows me knows how much I love Perkins. I do. It's a fun program. But you guys have some requirements. And if you have your defaulted loans that have been in default for 2 or more years, they are required to be assigned to us as soon as possible. This is a requirement that has been in place for several years now. When I used to work in the Office of Federal Student Aid with my colleagues Dave and others from here, we put this in place. Loans that are with a collection agency that have aged out at a collection agency for 2 or more years need to be removed back from the collection agency and assigned to the Department of Education. That's a requirement. Many of you, COVID, we suspended everything was crazy during COVID. The last thing we were going to do is make you assign Perkins loans to the department when you can't even get into your office and get the materials. I mean, that would have been kind of counterintuitive. So a lot of things have suspended, but this is up and running, and this requirement is back in play. So please look at your Perkins loan portfolio, and any loan that has been in default for 2 or more years, please work to get that assigned. We do have assignment processes that will work with you because these are very old loans, right? Loans 65 plus years old. You might not have everything. We work with you, so please don't think that every single thing, you have to have every piece and part, because we want to work with you on these older loans, okay? You do have administrative responsibilities, however, to report correctly on your FSAP. So for those of you that file the FSAP and you report information on there, we will break down the revolving fund into what's called a federal share and an institutional share. The federal share has to come back to the department when we call for it. The institutional share can stay at your school, but not in the revolving fund. When you had the revolving fund and we were making new loans, we wanted you to keep your institutional share and the federal share to make new loans. Well, we haven't made new loans since 2016. So now we break this fund down, and the percentages go to to us and back to you. You can use it for whatever you want, funding new scholarships, whatever that is. You take the money out of the revolving fund and you keep it. And that is based on the cash on hand, so your receivables, all of that fun accounting stuff, right? You know I don't like to do math. All of that, and we break it down with what you've contributed over time since the inception of the program and what the federal contribution was for the program. So please make sure that your FSAP is correct, because we derive so much of our information from that piece of part 3, okay? I don't want to tell you that you owe us thousands and thousands of dollars when you only owe us about 100, right? That wouldn't be fair. And so let's make sure you're following all of the requirements for Perkins if you continue to service those Perkins loans. If you have a servicer servicing your Perkins loans, it is still your responsibility to oversee them to make sure everything that they're doing is in line with these regulations. And on this slide, it tells you fiscal procedures. In 674, it tells you everything that you're required to do. And our handbook does an excellent job of explaining to you the things that you have to do. So please, make sure your FSAP is correct, make sure your defaulted loans are assigned, and make sure that when you fill out your FSAP that you complete it accurately so that we make sure we call the right kind of cash back from you, and you get to keep the right kind of cash for your institution. At this time, I get to turn it over to Dave.
All right, hello everyone. It's great to see everybody, and I mean that very sincerely. It's great to see you in person. We're very happy to have you here. I'm happy to be here with actual people and not being just a floating head on a screen, which I've been for years. I've gotten my corporeal body again. We're all good. First of all, thank you to Tammy. I feel like we should have like a little 7th inning stretch now. We've been through a lot. It's a lot of information to take in. I know that you guys have a lot of work to do on your campuses related to all of the changes to the loan programs. And I will also say Tammy and her team are doing an incredible amount of work. They are amazing colleagues, and they work every day to make sure that this works for all of you. I really appreciate her. Especially I appreciate that she's the one working on all the loan changes and not me. But let's go ahead and get started. We've got a lot to cover. I want to make sure we get through all of it. So I want to talk through some changes that the One Big Beautiful Bill Act, which I'm going to call OB3 for just for time purposes, made to the calculation process for Pell grants and for need analysis. So the first change that you see here, if you recall, before FAFSA simplification, the law allowed for assets that were part of a family-controlled small business that had at least 100 full-time or full-time equivalent employees, or a family farm on which the family resides. Those assets would be exempted from consideration in the student aid index in the need analysis formula. The FAFSA Simplification Act eliminated those exemptions. The OB3 brought those exemptions back. It also added a new one. There's now an exemption for commercial fishing business and related expenses, including fishing vessels and permits owned and controlled by the family. So the second change here, you see Pell ineligibility due to a high student aid index. In this change, it modifies the Pell Grant calculation to make a student ineligible for Pell if the student has a student aid index that equals or exceeds twice the amount of the maximum Pell Grant. And this was designed to essentially eliminate a rare circumstance where an individual, because of their family's income, qualified for a Pell Grant, but for other reasons, for potentially their family has assets that were quite high, they would have a very high SAI, but they would still qualify for Pell Grant funds. This change will cause those individuals who have an SAI that equals or exceeds twice, so that's double the amount of the maximum Pell Grant for that particular award year. It will make those individuals ineligible, and that will come back to you as part on the ICER. This does not apply. As always, there's an exception. This does not apply to individuals who qualify for the Pell Special Rule. As you know, it used to be called the Iraq-Afghanistan Service Grant and the Children of Fallen Heroes Scholarships. If they made those conditions, this particular item does not apply. Their SAI could still be any value, and they could qualify for Pell if they meet the conditions for a minimum Pell Grant. Finally, the other change here, the foreign income incorporated into the Pell eligibility calculation. So this essentially modifies the formula to allow for foreign income to be incorporated into the Pell Grant calculation formula without you as the financial aid administrator performing a professional judgment to make that change. Previously, that professional judgment was required, and now the law allows us to incorporate the foreign income directly into that calculation, so you don't have to take that extra step. The best news here on this slide is that all three of these changes have already been implemented by Aaron and his team on the 26-27 FAFSA and will be in place thereafter. So these are already being incorporated into student applications. So we had also we're making a number of improvements to the FAFSA partner portal. These are all upcoming improvements. You heard about these if you attended the FAFSA update presentation earlier this week. The ability to print the FAFSA submission summary, the ICER comparison feature, the ability for states to request ICERs by social security number, and updated application receipt timestamp is now available in Central Time. The other thing I want to talk through are a number of things. This is really more of a reminder. All of you are likely familiar with the department's efforts to reduce fraud. In summer 25, we identified some serious concerns related to fraud, specifically related to identity theft. And we made some changes first to our selection process for V5 verification. That occurred in what you see here on the slide in phase 1 back in June 2025. All first-time summer students were flagged for V5 verification. Then we moved on to phase 2, which occurred in August, where we did some targeted fraud screening and selected additional individuals for V5 verification. You've all been through a lot with those additional selections. You've all worked through those at this point, unless there are still a few that are outstanding. And we are now moving on to phase 3. And phase 3 is really where we've always been hoping to get. This is a process where the department will carry out an identity verification process in real time during the FAFSA application. And if the individual passes that verification, then verification by the institution will not be required. So we're working on implementing this in the spring, and so stay tuned for more information. But the intent with this is to reduce substantially the number of occasions where the department has to select a student for V4 or V5 verification for identity confirmation. Well, one person's excited, I'm glad. And so with those changes, we also made, and these are also a series of reminders for you, with those changes, we also made a number of changes to the ways that an institution can verify an individual's identity. The statement of educational purpose is no longer required as part of that process. We published this information in the Federal Register notice that was published on November 26, 2025. And we also provided a number of different new options for an institution to complete verification for V4 or V5 identity verification. So at this point, an individual could submit a valid government identification through either in person or through a video call with the institution. The second item here, you could also appear before a notary and have the notary confirm your identity and send that in. I want to note here that it's still not an option to do an online notary, even though that option exists. The department doesn't feel that it provides enough validation for our purposes to ensure that the individual is who they say they are. Another option that's now available is that an institution can work with a vendor that is compliant with what we call NIST, the National Institute of Standards and Technology, Identity Assurance Level 2. If you're working with such a vendor, if that vendor confirms the student's identity, you can consider the student's identity to be confirmed. Essentially, to document that is the case, you just need to ensure that you work with the vendor to have them produce documentation that they meet all of the requirements for NIST, for the NIST standards, and keep those on hand at your institution. And then finally, we added an option for individuals who are in prison education programs that the responsible individual at the prison facility can confirm their identity, since those are the folks that are in the best position to do that in a prison setting. Okay, so now let's talk through a very significant set of changes under OB3 for what we will be calling Workforce Pell. If you attended the excellent presentation earlier this week with Dave Bartnicki, you've heard a lot about these programs already. I'm going to go through some of the same information a little bit quicker, but some of you may not have been in that session, and I want to be sure that, that we talk through all the different aspects of this new authority. So similar to what Tamy shared earlier, we are on a very tight timeline to publish regulations pertaining to Workforce Pell. The One Big Beautiful Bill Act was signed back in summer of 2025. We announced our intent to establish the negotiated rulemaking shortly thereafter. We held the first session of the AHEAD committee from December 8th to 12th, and thankfully we reached consensus on that package. And I'm happy to say, as you heard the Undersecretary announce, the notice of proposed rulemaking has been entered into the pre-publication at the Federal Register, and it will be published officially on Monday. So you'll have a lot of information there to go through to look through what the department is proposing and in terms of specific regulations for these programs. You guys recall the disclaimer earlier. Much of what I'm going to discuss over the next few slides is part of those proposed regulations, and it is subject to change. However, it is the department's best effort at providing you with the most up-to-date information about what you can expect in the near future. I would also say we really want to hear from you about both this and the earnings accountability notice of proposed rulemaking that will be coming out in just about a month. Your comments are incredibly valuable. We want to be sure that we hear from the community about every aspect of this new provision because there are always things that we don't know, that we don't hear from our conversations and from our own research. Coming from you, it's incredibly valuable to get that new information. The only thing on this slide I want to point out is that you see the final rule to be published by the department is over by the June button. It's really likely to be published much closer to the beginning of May. We plan to move this as quickly as we can so that you as institutions have information in hand as well as states to get these programs approved and ready to be submitted to the department as of July 1st. All right, so what are eligible workforce programs and what is Workforce Pell? So effective on July 1st, 2026, the One Big Beautiful Bill Act creates a new type of Pell eligible program called an eligible workforce program that can be shorter than the current minimum program length. So you guys probably know that under most circumstances, the minimum program length for Pell purposes is 600 hours or the equivalent in credit hours. There are some exceptions if you require an associate's degree as a condition of entry into the program. However, in most cases, under current law and regulation, as of today, most programs would not qualify for Pell if they were shorter than that. This creates a new authority for a program called an eligible workforce program that must be between 150 and 599 clock hours or an equivalent number of credit hours, and must be at least 8 weeks but less than 15 weeks of instructional time in order to qualify. So these are very short programs that are designed to train individuals to meet local and regional workforce needs, and they're designed to work within the state framework for the Workforce Innovation and Opportunity Act that already exists. So we'll talk a little bit more about that in just a moment. So students in eligible workforce programs generally will meet the same eligibility requirements for Pell Grants as any other student, with some exceptions that I will go through. So in these programs, students, you will still calculate Pell exactly the same way. We've heard from some institutions that there's an idea that there's a workforce Pell grant that's different from the Pell grant. That's not the case. All of these are just Pell grants that you're providing to students who are in these eligible workforce programs. They have to meet the same student eligibility criteria, generally, and you'll calculate the Pell Grant awards in the same way that you would for any other student, which means you'll do proration in many cases to prorate the awards that the students receive down quite a bit for these very short programs that they're enrolled in. I do want to make a quick correction to something that we talked about earlier this week. We had a question at the Workforce Pell session earlier about whether a school could use Formula 1 to calculate a Pell Grant for a student in these programs. Generally speaking, that's not going to be an option because these programs are less than 30 weeks in length, and generally the Formula 1 requires you to have at least that many weeks of actual instruction in order to use that formula. But there are other formulas available to you. Formulas 2, 3, and 4 are options to calculate these Pell Grants for these students. We'll go through some of the exceptions to student eligibility. But students cannot qualify if they have a graduate credential or if they are currently enrolled in a graduate program. But the really mind-blowing thing for most of us, as Dave pointed out yesterday, otherwise eligible students with bachelor's degrees are eligible for Pell if they are enrolled in eligible workforce programs and otherwise meet all of the criteria that they need to meet. So we've actually done some work. Aaron's team has built a process that will be implemented in the FAFSA partner portal for institutions to identify students as being enrolled in an eligible workforce program so that their Pell Grant can be calculated in the system and you can award Pell to those students. Okay, so in order to get your program approved, the law provides for a series of things that you need to comply with. The first set of requirements are things that the state has to approve. This has to occur before the application comes to the department. So there are several items that you see here on the screen. The program must be aligned with high skill, high wage, or in-demand industry sectors or occupations. It must meet the hiring requirements of employers in the sectors with which it's aligned. The program must be stackable and portable across more than one employer or lead to the only recognized credential that's available for that particular occupation. And students who complete the program must receive academic credit, they must receive academic credit toward a certificate or degree, either at the institution where they're enrolled in the program or at another institution through an articulation agreement. So these items are largely aligned with WIOA and the existing requirements for a program to qualify for assistance under WIOA. So you may have individuals at your institution who are already familiar with these requirements for their WIOA programs. The department in its proposed regulations is trying to align these as much as possible with WIOA as well. The notion with this program is that the Workforce Pell would overlay the WIOA aid so that individuals could qualify for a Pell Grant if they meet those conditions. But in some cases, if they don't meet the conditions to qualify for Pell, they could still qualify for assistance under WIOA for these workforce programs. So the department's intent here is to give states the maximum flexibility to define these as they always have, if it's a WIOA definition, and to define it in the way that suits them best if the definition is new to them in this context. So we will be providing more information about what these terms mean in the proposed regulations and in the final rule. I know many of you may be shaking your head and wondering what stackable and portable means. We will give you more information about that, and we do plan to provide eventually, in partnership with the Department of Labor, guidance to states to help them implement these requirements as well. I would also add that states are required to publish their process for approving these programs. So it's in your interest, if you're interested in offering one of these programs, to reach out to your state and ask them how they're planning to create their approval process, because that's a really important part of this process. One thing that's not on this slide is, in addition to obtaining state approval, you'll also need to ensure that the program is accredited and falls into your institutional accreditation. Many accreditors may not currently evaluate workforce programs that are non-credit, so it's important for you to reach out to them and make sure that they are ready to review and approve these programs, or simply evaluate them and put them into the scope of your accreditation at the institution. Once those two conditions are met, we move on to the requirements determined by the Department of Education. So here we will do some of our basic checks on program eligibility that we would always do. We would check to make sure the program is at least 8 weeks, but less than 15 weeks of instruction, so the maximum is 14 weeks of instruction. It has to be between 150 to 599 clock hours or an equivalent number of credit hours. It can't be offered using correspondence courses or study abroad. Remedial and non-credit coursework don't count toward Pell Grant eligibility. I want to pause here and mention that when we say non-credit coursework, we don't mean that coursework that the clock hour programs, for example, do not qualify. There's quite a bit that we've always had the ability to offer Pell in clock hour programs, but what we mean is you can't tack on additional coursework in these programs in order to make the program eligible. So I'm seeing my colleague over here. I know we're getting low on time, so I'm trying to run through these as quickly as possible. So we also have completion and placement rates. These actually will be calculated by your state. So there's good news and bad news there. They'll be calculating the placement rate under the department's proposed rules. You'll also likely have to provide them with some information in order for them to calculate the completion rates, but you're not responsible for calculating those like you would be with the programs that qualify for aid for short-term programs that qualify for direct loan only. The last thing I want to mention about these is that there's a process for creating a value-added earnings metric that pertains specifically to eligible workforce programs. The metric compares the median earnings of graduates with the federal poverty level and makes some adjustments for regional price parities. The difference between these two values is called value-added earnings. We will evaluate the earnings of individuals who graduated from the program several years prior. Value-added earnings will apply to eligible workforce programs in the 20, 30, and 31 award year. So the department is interpreting this to be a forward-looking evaluation, so that when you have eligible workforce programs for the first time, this won't apply because there are no graduates for us to evaluate their earnings. Only after they've been in the workforce for a while would this apply. But ultimately, once we calculate the value-added earnings, what will happen is that will limit the amount that an institution can charge for the program. The tuition and fees cannot exceed the value-added earnings that the department calculates for the program. All right, so I want to go through, this is a very important topic. We will probably skip through the remaining slides at the end, but I want to take some time to talk through this. I apologize that folks won't have much of a break between this and the next session, but we want to talk through, we haven't had an opportunity to talk about earnings accountability in any other context. This particular provision in the law was all part of the One Big Beautiful Bill Act, as the other one was. We conducted our negotiated rulemaking session on this in January. We also reached consensus here. We plan to publish the notice of proposed rulemaking in April, and we'll have a 30-day comment period for that. We also plan to publish this before July 1st, around the end of May, early June. So stay tuned for that as well. So the One Big Beautiful Bill Act creates a new set of standards for programs of study to be included in an institution's participation in the direct loan program. When we fully implement these provisions, a program of study's direct loan eligibility will end if the median earnings for the program's graduates falls below statutory thresholds for 2 out of 3 consecutive award years. And schools must agree to this framework as of July 1st, 2026, which is why we're rushing to complete these regulations. Just as Tamy said, the Congress understood that this was not something that we would have time to regulate through the normal master calendar process. So we're working as quickly as we can to implement what needs to be implemented as of July 1st. And then there will be a longer timeline after that, during which the department actually calculates the metrics, provides that information to institutions, and takes further steps from there. So under the department's proposed regulations, all Title IV eligible programs would be subject to the new earnings accountability framework, including undergraduate and graduate non-degree programs, bachelor's degree programs, associate degree programs, graduate and professional degree programs. All of these types of programs were previously not subject to eligibility consequences if they failed the existing metrics, unless, and I know that this asterisk says that they would not be subject, but our proprietary school colleagues know that their programs would have, but the department's proposed regulations would align this for everyone so that all programs are subject to the exact same requirements. There are still some minor exceptions, things like prison. There are cases where, for example, comprehensive post-secondary and transition programs for students with intellectual disabilities, those will not be subjected to this. But by and large, all other programs would be subject to this. Now, under the earnings accountability process, a program would fall below the standard if the median earnings of the graduates who graduated from the program do not equal or exceed the earnings threshold. That threshold is the median earnings of working adults aged 25 to 34 with either, for undergraduate degrees, a high school diploma, or for graduate or professional degrees, a baccalaureate degree. So you can see the intent with this is to evaluate the earnings of individuals in a program at a particular level of offering against those of individuals who have the next lowest level of offering. Essentially saying, did this program provide enough value to make it worthwhile given what others are earning for the lower amount? Won't have too much time to go through this, but the earnings accountability thresholds are calculated in some different ways for undergraduates and graduates. If you're an undergraduate, that threshold, so the denominator, or the comparison group for this process, is calculated in one of two ways. Either if the institution enrolls mostly in-state students, it would be the in-state benchmark for students with high school diplomas. If the institution enrolls mostly out-of-state students, it would be a national benchmark. For graduate programs, it's the same. We have the same breakdown on this chart. If most of the students at the institution are in-state, then you would use the lowest of the same state, same field baccalaureate holder benchmark, the same state general baccalaureate benchmark, or the national same field baccalaureate benchmark. So this is essentially trying to evaluate, this one is subjecting graduate programs to a slightly stricter standard. It's trying to look at really, did this program provide value based on what this person is going to be entering, the specific field? And if you have more than half of your students who are at the institution enrolled who are from outside the state, we would use a national same field baccalaureate benchmark or the national benchmark generally, not looking at the field. So I want to talk through briefly what the differences are between this new authority and the existing gainful employment authority. The existing authority applies only to gainful employment programs when you're talking about accountability, whereas the new earnings accountability would apply to all Title IV eligible programs, both GE and non-GE programs. The current gainful employment process has two tests. It's a debt to earnings test and an earnings test. The earnings accountability framework would only have the earnings test. So under the department's proposed regulations, the debt to earning test would go away. We would not have that test, and we would make all of the changes accordingly. Under the current GE, we would measure earnings at the 3-year median earnings. Under the new framework, we would use a 4-year median earnings, and we would only look at working individuals. That's a big difference from the way that the rule is currently constructed for GE. And GE looks at both non-working and working individuals. Under the new framework, we would only look at working individuals based on whether they have any income on their tax returns. There are a number of different other things. I won't spend too much time. There's an aggregation process for cohorts, and I do want you guys to hear this information. The law requires us to, if we don't have enough individuals in a cohort for an award year to calculate this metric, we are expected to go back to earlier years and include individuals from earlier cohorts. And then if we still don't have enough individuals to calculate a metric, we're expected to broaden that search to similar programs at the same credential level. So the department is building a framework to go through that process and continually expand these cohorts until we have enough students to calculate a metric. If we ultimately still don't have enough people after all of that expansion, then the metric would not be calculated. And let me talk really quickly at this last point. The sanctions for GE currently is the loss of all Title IV aid. The sanctions under the new framework is loss of direct loan eligibility for the program. However, if more than half of your Title IV revenue or more than half of your students are in failing programs that have lost direct loan eligibility, all of those programs would also lose Pell Grant eligibility under the department's proposed rules. So there will be consequences if many programs at an institution are in this situation where they're failing this metric. Really quick, I know this is also a headline for you guys before I wrap up, but we are also making some changes to reporting requirements. And so probably that you guys are asking, really, what are the changes to the reporting requirements? That's coming up in just a few months. So the department is now turning its focus away from some of the broader requirements in that reporting toward information that would be useful for calculating net price primarily. And we're eliminating numerous reporting requirements. So on the left hand of the screen, you'll see the items that we propose to keep. That includes things that student identification, accreditation status, adherence to licensure requirements, total numbers of programs, students in the program, identifying information, cost of attendance, tuition and fees, really important for determining net price, residency status, and then all types of Title IV aid already received. We did eliminate some items that institutions reported were very difficult to determine, things like whether the program is a qualifying graduate program. We don't need that for the current process. Attendance dates and enrollment dates, we already have that information in the National Student Loan Data System, NSLDS. Completion and withdrawal dates, same thing, we've got that in NSLDS. And then institutional debt at the time of completion or withdrawal. We don't need that either to calculate under the new framework that only looks at earnings. So stay tuned. This is something that the department proposes to allow schools to early implement once we publish. So what that would mean is you should expect to do reporting for this process in the fall as you have in the past, but there likely will be some items that you're not required to report, and that'll be explained in the final regulations. All right, and I'm going to skip through this because we've run out of time. Thank you all so much. We really appreciate all that you do, and I'm so glad to have you here with us. Thank you.